I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we are continuing to discuss research data, this time from an EU perspective. On a past episode, we discussed the US rules relating to the collection, use, and possible reuse of data collected in research studies with my colleague, Melissa Levine. If you missed it, check it out. It was fantastic, and it left many of our clients coming and asking for another episode to cover the rules relating to research, this time in the EU. As we mentioned in the prior podcasts, research has always been one of the most challenging areas of data protection law because of the overlap and interaction between, at least in the United States, federal and state rules, general and sensitive data laws, data protection, human subject, FDA laws. And that's really just thinking about it from a US lens. If you add the EU's GDPR, local country laws, what often feels like a general mismatch between the expertise between sponsors and research sites, investigators, review boards, CROs, and so many others that are part of the research ecosystem, I think you clearly see the complexity that arises. To bring sense and order to that chaotic field of research in the EU, I have invited my partner, Patrice Navarro, from our Paris office to the podcast. Patrice has decades of experience in data protection with a particular focus in life sciences, research, and sensitive data. Patrice, welcome to the podcast.
Thank you, Scott. I'm so happy to join you today, especially on a discussion around secondary research data use in Europe, as we will discuss about today, as it's a topic that we are encountering with increasing frequency from our clients. As I am a partner in Paris, as you said, with decades of experience, I'm coordinating a lot of projects around health data in Europe, working mainly in the healthcare sector. And I think it's an area that is particularly fascinating, given all the rapid advancement right now. It's really the right moment to be in that. There's connected devices, AI, and other technology that all relies more and more in data utilization, actually. There's an increasing need for data. That was not the case a few years ago, which explains why there's so much need and appetite for existing data set and the possibility to reuse data that collected previously.
Yeah, I'm very interested in learning about the data reuse, but maybe we can just start if you can give us an overview of what are the laws and regulations governing research within the European Union?
Yeah, of course, Scott. So very basically, all the clinical trials are the main source of data, and that will be interventional clinical trials, the most common traditional one, the one that you have to make sure you have your marketing authorization for your drug, for your product. You have also the non-interventional studies, but increasingly there's a focus on pure data research, such as past, retrospective data studies. That's really should be termed, that should be called data studies. And there are a lot about using pre-existing data that are on file or sometimes through questionnaire. And this part is not fully regulated, but everything will fall under the GDPR, but also what is peculiar. It's a case on health data always in the healthcare sector in Europe, but even more for this type of studies, there's local regulation. Each country will have its own regulation. In France, that will be in the French Public Health Code. And then you also have European text on top of that, not the data text, not data protection, not GDPR, not AI Act, but you have public health regulations, which are talking about data a lot. That's many provisions about data, about reusing data, and that's the CTR and the MDR, clinical trial regulation, and the medical device regulation.
Yeah, I mean, interesting. So you're drawing a distinction that almost is kind of a threshold question. What type of study are you conducting? Are you looking at a study where you are looking at data that had been collected in another context and now conducting new research on that data? And it sounds like there are kind of rules that would need to be followed for that type of study. And then also maybe more like a clinical trial or a clinical study where you're collecting new data for the very first time for research. And then there are rules with respect that type of study. Is that fair?
Yeah, you're perfectly right. Exactly. What we're talking here is about retrospective studies, previously collected data. It's client pharma company, medical device manufacturers that realize that they are sitting on a bunch of, or huge amount, in fact, a huge volume of data that could be reused for AI application quite often. And that's vital for our client to be able to use them. But that's not fully recognized by the current legal frameworks in Europe. So that's presenting a challenge. Quite often, most common scenario will be pharma company has a lot of data from previous clinical trials that was used for to obtain to support the marketing authorization request. And then they are discovering the potential new use. It has value. All this data can be used for something else, not totally different, but maybe for a new drug treatment, maybe a new indication. That's where there's a question on it's raised the possibility to reuse.
Yeah, I mean, it also sounds like in addition to trying to identify the type of study that you're doing and that impact that that will have on the regulations themselves may differ depending on country. So the GDPR, one of the areas where I think that it has excelled is that it has provided a common framework for all of the EU member states to work under from a data protection perspective. In the United States, I think many of our clients are envious of that, given that we have to work with so many specific state rules. Not the same in the EU, where we have a one common framework, except that what I'm hearing you say is that there is not necessarily one common framework in the EU with respect to research data.
Yeah, no, that's a really good question. Everyone believes that the GDPR will harmonize, and that was the goal. But that's not the whole story. Not everything is about the GDPR here. We are supposed to harmonize, but there's opening clauses in the GDPR. So, and a lot of them are concerned with health data, sensitive data. And it's when I say opening clauses, it means that countries, EU members, the 27 countries in Europe, can have their little diverging points and way to regulate and to frame this use of data. But it's more complex than that. In fact, when we are talking about healthcare, there's a lot of nuances at the national level, simply because, as I was saying, for France, you've got a public health code, and there's so many regulation about healthcare data in it, in this code. It's huge, and that's the same in every country. And then you have all the specificities that you have to accommodate one by one. In some countries, they are really used to, they want, and that's a kind of habit, to use consent a lot, where in other countries, they will recognize that consent might not be freely given in this sector. So there's so many differences to accommodate. That's doable, but that's a lot of work.
Yeah, I mean, so how does that work out in practice? Because oftentimes, when we're looking for strategies to cut across multiple areas of regulation, we are often looking for the most restrictive, the least common denominator that may allow compliance with multiple regulatory regimes. You're describing a scenario where one country may require consent and other countries may say consent is not appropriate. How does that play out in practice in terms of creating a unified research oriented set of documentation to apply to research, whether that be the notices, the consents, the research protocols? How does that look?
So we develop strategies and an approach for that. On the one hand, of course, everyone would like to have one unique protocol, one unique ICF, one unique notice. It cannot really work that way. But on the other side, it's not possible either to have 27 distinct set of documents in Europe for each country. Quite often trials, for example, will be launched in a huge number of countries. And it's not possible just from a operational standpoint to have all these various approaches. And it's even creating risk because if you create gaps, too many gaps, you're trying to be 100 compliant in every and each country. In fact, you're creating risk. I don't say that we should not comply, but there's ways to find harmonization, like by areas. So you have one set of documents. We were talking about consent. So you may have one set of documents for all the countries that are really adamant on using consent. Then you have the countries without consent, where you will have another legal basis. Then you may have a few countries in between, but that way you are able to manage and protect your data correctly and mitigating all those risks properly.
So it sounds like those complexities would arise, even for new research. But let's go back to, one of the issues that we talked about at the very beginning, and that is using data that was collected historically for new research studies. In those cases, there may not be opportunities to present new notices and provide new consents. How are European researchers dealing with those requirements?
We are back on also on consent, and that's key to admit that consent as a first initial legal basis won't be really good because you might need to reconsent. Yeah, that will be pretty hard to get reconsent from the patients, and maybe several years after, really hard to find them. Some of them, unfortunately, may have passed away. Plus, as a pharma company or medical device manufacturer, especially in clinical trials, you're not supposed to get the name of the patient. So if you want to recontact them, you will have to go through the investigators. So there's other ways of doing that. If you avoid consent, there's some possibility under the GDPR to reuse and to consider that your new legal basis, your new purpose is compatible with the first one, and you reuse the same legal basis than initially. But there's a few rules to respect still. There's way of strategy to do that. And the first one is what I call opening the door. You have to open the door first in your ICF, at least in the data protection notice that you have with your ICF. You have to tell people, you have to tell patients, you have to inform, to be transparent about the fact that the possible secondary purpose of the data that you're collecting. Of course, you cannot say everything because you don't know. You don't exactly know that what you will need, what you will do exactly in a few years' time. But at least you have to provide some measures of information, and then you are offering the possibility to opt out. That's what we recommend. It's being very clear that patients, and we are mainly talking about patients here, there's other kind of data subjects, but mainly focusing on patients, they will need, in most countries in Europe, it will be key to offer some kind of opt-out possibility for this further research, future use, secondary purpose, whatever you call it, in order to be able to show that you are protecting, you are applying GDPR, you are protecting data subject and preserving that data.
Yeah, so it sounds like one of the really important things, and as a practice point for folks who are in this space, is to make sure that documentation for existing research studies or future research studies are anticipating the reuses of information. And I guess maybe the question in my mind about how to think about legacy data, because Patrice, I'm sure you're seeing the same questions that I am, in that there is an increasing interest in historical data sets, especially with the widespread interest in AI and machine learning, to look at data that was collected perhaps decades ago in the 80s and the 90s and the 2000s to try to find new types of correlations that may not have been the subject of those early research efforts. How do you think about those historical data sets? Are they off limits to research, or are there ways to think about how to unlock their value?
Yes, you're right. We are encountering this kind of issue really often, and certainly legacy data present a challenge. Quite often, ICF, informed consent form from decades ago, were lacking all the detail that are now standards. Even if you can say that in most countries before the GDPR there was already some kind of obligation to inform, but still, these old ICF were not opening the door enough. So you can try re-informing participants, obtaining new consent, theoretically still an option, but in practice, very difficult, especially since, as I said, pharma companies and medical device manufacturers, they do not have direct access to the patients. They don't have the direct identifiers. So if you get back to your retired investigator, quite frankly, you won't get in touch with these old patients. So what is left? You've got anonymization. It's possible, but remember that the standard, the European standard, is very high. It's very stringent. Uh, we are still waiting for some better guidance on that. But for now, to say that your data is anonymized, and I have to say that if it's anonymized, you're out of the GDPR. You're safe. You can do whatever you want, almost. But you do not have to apply GDPR at all if it's fully anonymized. But it's not just de-identification. It's about not being able in any way to re-identify, to reattach the data to the individual. It's really hard to reach as a standard. So we are still waiting for this further guidance from the European Data Protection Board. It has been delayed. There's probably a fight in the back office about being more pragmatic or not. For now, it's especially in when we are talking medicine, health data, it's really hard to say that I have this bunch of useful data, but it is sufficiently anonymized, because if you combine data and then there's some measure of objectivity, like there's often a way to re-identify.
Right.
I wanted to say that for me, it's a very significant barrier to innovation. That's a shame. We should be more practical. It's a bad idea to have such kind of standards that are really putting constraints on innovation and research. There's probably ways to protect data subjects and their data and their privacy and their liberties, and still giving more flexibility for data analysts and pharma companies to research new treatments.
Right. I mean, especially in the context of health, where uses of data could unlock, value and, ways of improving our kind of our lives for generations to come. And so by implementing so many barriers to that, it creates, I think a disincentive almost to try to create that long-term value. I guess, Patrice, one question for you is if I'm hearing you right, especially around that anonymization point, there's often a misconception where if folks say, well, I'm looking at this data set and I can't identify Scott Loughlin's data or Patrice Navarro's data or anybody else's data. That data has all been quote unquote coded, replacing traditional identifiers with a code. That itself is not going to achieve anonymization, given the heightened standard that GDPR puts into place. But I also heard you say that there is actually some debate within side of maybe the EU or at least with the UK about what type of flexibility that companies have in terms of conducting research and achieving anonymization. Is that right?
Yeah, that's right. That's the nexus of the debate. I call that objective or subjective. Might be not exactly clear, but the thing is that it's exactly the example that you have been taking. Is it myself when I look at the data? Can I reattach to someone, or is it someone somewhere, anyone, involving a lot of resources, huge amount of money, including breaking into premises? That's really the case. If I can reattach the data, I can re-identify the data by doing all of that, most of the countries in Europe will consider that it's not anonymized. So even if you have to be a hacker to get to the correct database, they will consider that if it's possible in the absolute, if it's possible, then it's not anonymized. Other countries, like the UK, for example, UK being not anymore in the EU, but the UK has a clear, especially in the health sector, a clear, more practical approach. So more flexibility. Saying it depends on what myself as a controller, as a pharma company, if I can re-identify or not. And then, of course, it's much easier. That's a huge debate, and that's probably why all these guidance have been delayed. We are still waiting for it, and we really hope for a better balance in Europe between European regulators to adopt a more realistic approach on anonymization. Still, we need that for innovation. We need data more and more, and we can do it while ensuring data protection, but we need all those data.
As you describe this, Patrice, not only kind of that debate, but also kind of the complexity of conducting research in the EU, it doesn't sound that dissimilar to what we have in the United States. It sounds like there is these overlapping, competing laws, both at the regional level and then at the local level. It sounds like there are competing priorities about how to protect individuals versus trying to unlock the potential of all of this data. And so, while the rules may differ, what sounds like is in common as I think about how organizations are approaching this globally is there is no one size fits all approach to research compliance in the United States, and there is not one in the EU. Each research project has unique legal and data protection considerations, which really emphasizes the importance of thoughtful and deliberate planning in setting up research projects today, whether you're looking at old data, new data, or how to do this in the future.
Yeah, you're perfectly right. There's not one way, only one way. It will depend on each project. And planning from the outset, it's crucial really to be where you might really regret as a pharma company having gone too far too fast without really thinking things over. Because actually, even if it's difficult to put in place, most authorities in Europe will recognize that it's a balance. So you have all these different principles from the GDPR. Soon you will have the AI Act with also a set of principles and rules. But even the French Data Protection Authority, which is one of the stringent authority, will tell you that there's also some kind of balance. If you that your information is not perfect, but you are very high on the other principles. You are really, really setting in place a strategy, privacy by design. You have to think about it. Privacy by design from day one. Then I have anticipated. I know that everything is not fully 110% perfect, but I'm protecting data. I'm putting myself in the shoes of the data subjects, of the patient. I'm protecting them. I'm doing everything to protect and comply as much as possible, and keeping in that in mind. And that will be even more important with the upcoming regulation like the AI Act. It's key to think already today here about what we will do, how we will construct new tools in order to be compliant for future technology and all of the tools that you will put in place. They have to be compliant and ethical, and you have to analyze that now to avoid potential setbacks like on the day of entering into force of the AI Act, you have to turn off your brand new shiny tool.
Yeah, I mean, that's fascinating. Patrice, your insights today have been incredibly valuable. With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.